Freedom of religion, guaranteed in the First Amendment to the Constitution of the United States and cherished by Americans. Today, the U.S. is home to hundreds of religious denominations, and all members of the United States military are allowed to choose the religion or non-religion stamped on their identification necklace or dog tag. This may include atheist, agnostic, or even Jedi. But back in the 1940s, during World War II, if you were a member of the American military, you could choose only one of 3 religions to be engraved on your dog tag: Protestant, Catholic, or Hebrew. In the early 1950s, the New York State Board of Regents authorized all public schools in the state to start their day with a short, voluntary, non-denominational prayer. The 22-word prayer read, "Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country." Some parents in a school district that used the prayer objected that it violated their religious views and the First Amendment ban on the establishment of religion, so they sued.
Hi, I'm Doug Ginsburg, and I'm a federal judge. The place of religion in public schools came before the Supreme Court in the case of Engel versus Vitale in the early 1960s. But the controversy is as relevant today as it was then. The lawsuit was brought by Stephen Engel and the parents of other school children against the local school board president, William Vitale. Although the participation by a pupil was voluntary, the parents claimed that the schools were promoting religion. When New York State's highest court rejected their argument, the families did not give up. 11 years after the prayer was authorized, their case was heard by the United States Supreme Court. It was 1962. The question for the court was, did the school's voluntary prayer violate the Establishment Clause of the First Amendment? The First Amendment provides, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The justices reasoned that by promoting this prayer, even though it was non-denominational and voluntary, the state of New York was effectively endorsing a religious activity. After oral arguments and deliberations, the justices voted 6-1 in favor of Engel. The majority opinion was written by Justice Hugo Black, in which 4 justices joined, 1 justice concurred with different reasoning, 1 dissented, and 2 recused themselves. The ruling held that the New York Board of Regents had violated the Establishment Clause of the First Amendment to the United States Constitution. Justice Black wrote that the official prayer breached the wall of separation between church and state, a metaphor first used by Thomas Jefferson to describe the religion clauses of the First Amendment. Not all Supreme Court decisions are popular, and many viewed this one as an infringement on religious expression. It was met with significant public outrage and widespread controversy. But courts and judges are not to be swayed by popular opinion. The judge's obligation is to follow the Constitution as he or she best understands it.
Engel versus Vitale was decided in favor of Engel by a 6-1 majority vote in 1962. The key principle was the First Amendment's Establishment Clause. The court held that school sponsorship of religious activities violates the Establishment Clause of the First Amendment.